today is truly historic. This has never occurred. Nothing like this has ever occurred. You know, under Article 1, Section 3, Clause 6, we've been given a duty. We've been given the sole exclusive power to try all impeachments. Try all impeachments. Not some of them, not just those with which we happen to agree, not just those that we are happy that the House of Representatives undertook to prosecute, but all. The word try is also significant. It refers to the word trial. It's the same word. It's a proceeding in which the law and the facts are presented to finders of fact in front of judges in order to reach an ultimate disposition. In a criminal proceeding, it would be an ultimate disposition culminating in a verdict of guilty or not guilty. We were precluded from doing that job today, and we were precluded from doing so in a way that is not only ahistoric and unprecedented, but also counter-constitutional. Nothing could be further from the plain structure, text, and history of the Constitution than that. So let's look at the arguments that we would have heard, that we could have heard, that we should have heard today, had things unfolded as they were supposed to. Had things unfolded in a manner consistent with the oath that we took, first when we were sworn in as United States Senators. We're all required to take the same oath to the Constitution when we did that, but also the oath that we took just a few hours ago in this very chamber, in this very case, to decide this case impartially. What would we have heard? Well, first and foremost, regardless of what you think about what a trial consists of or how different people might cleverly define the term, a trial will always, at a minimum, involve lawyers. And unless the person is proceeding pro se, you will always have lawyers there. Or at least one side will always be represented by lawyers, and in 99.9% of all cases, both sides will. You will hear from lawyers. We didn't hear that today. We didn't hear from the committee of individuals appointed by the House of Representatives to be the House impeachment managers or prosecutors. What else would you expect to hear? Well, you'd hear evidence. Evidence would be brought in. Sometimes trials in the Senate involve bringing in evidence in a documentary form. Other times you might have witnesses. We didn't have any witnesses. We didn't have any documentary evidence other than that which was charged. So let's talk about what was charged and what evidence we could have, would have, and should have heard had we done our job today. Well, the accusations in this impeachment trial can be fit into two categories. Category 1 is found in Article 1 of the Articles of Impeachment. Article 1 alleges that Secretary Mayorkas repeatedly, defiantly did the exact opposite of what federal law requires, namely that under myriad circumstances, 8 or 9 different statutory provisions that he violated, he was required to detain people whom he did not detain. But it's not just that he didn't do what the law required. He did the exact opposite of that. Instead of holding them until such time as they could be removed or alternatively adjudicated to have the status, whether under whether in the context of immigration parole or asylum or otherwise, he just released them. And in many cases, gave them work permits. We would have heard evidence about the fact that memoranda issued by Secretary Mayorkas within the Department of Homeland Security didn't just tolerate this result, they instructed this result. We would have heard evidence about the fact that at the outset of the Biden administration, Secretary Mayorkas, when asked what he would tell those traveling through the caravans, those paying many thousands of dollars per head, in some cases tens of thousands of dollars per head, to international drug cartels, instead of telling them don't do it, he said, maybe don't do it yet. Give us a few weeks before we're ready to receive you. Showing intention, a forethought, to facilitate the violation of federal law. We would have heard evidence about how he instructed his own department to violate those rules. We would have heard evidence about how directly contrary to federal law those things are and contrary to his own oath and his own duties. Now, as to Article 1, The Senate chose to dispose of this today by doing something it's never done in any context anywhere close to this, with a point of order that said as follows. The majority leader stood up, defiantly refusing to have the Senate perform its obligations, and raised the following point of order. He said, I raise a point of order that Impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution is therefore unconstitutional. All right, let's talk about that for a minute. Now, had we been permitted to have a trial, alternatively, had we been permitted to go into executive session, alternatively, had we been permitted to go into closed session, as several of us moved today, we would have been able to hear arguments about this, about how wrong this is, because that's what you do when you have a trial. You hear evidence, you hear arguments from lawyers, and when someone makes a legal argument, as Majority Leader Schumer just did, you can consider their implications, and most importantly, consider whether or not the argument is right. Because when we're sworn in a trial of impeachment, our job is to serve as both finders of fact and adjudicators of law relevant to this case. We were denied that opportunity. So while we're exploring what we would have heard had we gone to trial, had we done our job, let's also explore what would have happened in a real trial had somebody made an actual motion and we've been permitted to do our job. Well, look, first and foremost, this is patently absurd to argue that a willful refusal to obey the law that one has a sworn solemn obligation to perform is somehow not impeachable. We don't have to look too far in order to find support for the conclusion that this is an illegitimate, unwarranted, unsubstantiated claim, one that's directly contrary to law. In fact, we don't have to look further than President Biden's own lawyer, the Solicitor General of the United States, who holds a special position within our federal government, performs functions that many people mistakenly associate with the Attorney General. But it is, in fact, the Solicitor General who is the United States government's chief appellate advocate and chief advocate before all proceedings in the U.S. Supreme Court. There was an exchange in a case argued last term in the Supreme Court of the United States called United States versus Texas. In that case, the Supreme Court heard arguments from the state of Texas about whether or not this administration's approach toward these same provisions of law is acceptable, whether or not they could challenge them. Now, unfortunately, the Supreme Court reached a conclusion with which I strongly disagree, and the Supreme Court concluded ultimately that the state of Texas lacks standing to challenge federal policy along the lines of what we're discussing today, notwithstanding the fact that it's conduct that inflicts substantial harm on the state of Texas and its residents. But the important part that we should have been able to argue here today is the exchange that occurred at oral argument between Justice Kavanaugh and Elizabeth Prelogar, Solicitor General of the United States, in her capacity as Solicitor General, as the Biden administration's chief appellate advocate and chief advocate before the United States Supreme Court. Justice Kavanaugh asked her a number of questions at oral argument, and on page 50 of that argument transcript, some of that discussion ensues. He asks the following: if a new administration comes in and says we're not going to enforce environmental laws, we're not going to enforce labor laws, your position, I believe, is that no state and no individual and no business would have standing to challenge a decision to, as a blanket matter, not just not enforce those laws. Correct? Here's what Solicitor General Prelogar says. Quote, that's correct under this court's precedent. But the framers intended political checks in that circumstance. You know, if an administration did something that extreme and said we're just not going to enforce the law at all, then the president would be held to account by the voters, and Congress has tools at its disposal as well. So this argument continues on to the next page, in which Justice Kavanaugh says what are the exact tools that Congress has to make sure that the laws are enforced. And And Solicitor General Preligar answers. She says, well, I think Congress obviously has the power of the purse, and she goes on to explain how this is relevant. And then this goes on until we get to page 53, and then at page 53, Justice Kavanaugh jumps back in and says, I think your position is, instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps of some sort or another. Solicitor General Preligar responds by saying, well, I think that if those dramatic steps would be warranted, it would be in the face of dramatic abdication of statutory responsibility by the executive. So she just acknowledged exactly what has happened here, and she acknowledged that is exactly the moment at which the impeachment power becomes very relevant. Lest there be any doubt on that, this stuff was settled not just in 1789, when we adopted the Constitution, and when the framers used the language that they did. But remember, the framers were not operating in a vacuum. They were not writing on a blank slate. They were incorporating legal terminology that had been in use for centuries. In fact, Justice Story, in his treatise on the Constitution, discusses this very kind of thing and explains in section 798 of his famed treatise, written not so very long after the Constitution itself was written, that we got this stuff from England, that the British knew what impeachment meant, and they understood what would constitute a high crime or misdemeanor. In section 798, Justice Story acknowledges that there was precedent, there was an understanding at the time of the founding that recognized that you would have an impeachable offense if, among other things, a Lord Admiral would have neglected the safeguard of the sea. They didn't have a Homeland Security Secretary then, not in America, not in Britain. But this is really analogous. This is the exact same thing. Somebody who had a duty to do a certain thing under the law defiantly refused to do so. Those are arguments we could have and would have and should have heard today had we had an actual trial, had we been permitted even to go into executive session or even to go into closed session. Why closed session? We don't want to have to do it in closed session. But you see, the standing rules of impeachment in this body preclude us from having this very kind of debate. So when Majority Leader Schumer made this argument, to the great shock and surprise of all of us, we wanted to warn the body and have this debate. He wouldn't let us do that. The Democrats voted us down. So that's Article 1 in a nutshell. Article 2 of the Articles of Impeachment, what do those get to? Well, those are interesting because those deal with false statements, knowingly false statements repeatedly made by Secretary Alejandro Mayorkas to Congress. To Congress, as it's performing its oversight responsibilities. He lied to Congress according to the allegations of the Articles of Impeachment in Article 2. To my great shock, he was dead wrong as to Article 1. But if he was dead wrong as to Article 1, he was deader than a doornail, whatever that means. 10 times more dead as a doornail as to Article 2 than he was to Article 1. Why is that? Well, because they allege in Article 2 that Secretary Mayorkas knowingly made false statements. Knowingly making false statements is a felony offense. It's punishable as a crime, as a felony federal offense under, among other things, 18 U.S.C. Section 1001. It's routinely charged, prosecuted, and is the basis for lots of convictions for a felony offense. You can go to prison for a very long period of time for that. Now, for Chuck Schumer to argue...
Senator Yield.
Yes.
I just want to be able to be sure I understand, Senator. I thought I heard...
Microphone.
Madam President, I asked Senator Lee if he would yield to a question. I thought I heard Senator Schumer argue today that lying to the United States Congress was not a high crime or misdemeanor, and therefore could not be the basis for an article of impeachment. Did I hear that correctly?
That is exactly what he said. That is exactly what he said when he made this motion, because he stood up and he said, I raise a point of order that impeachment Article 2 does not alleged conduct that rises to the level of a high crime or misdemeanor.
So, even though lying to the United States Congress is a felony, under the precedent that the majority leader and our Democratic colleagues established, it's not a high crime or misdemeanor? Is that what we did?
That is precisely what the precedent established today stands for. That is, we've effectively, by this vote that the Democrats forced through, not even allowing us to debate this, and this is why I raised a point of order on, or this is why I made a motion that we go into closed session to discuss this, because we've now set a precedent that effectively, very arguably effectively, immunizes from impeachment, making a false statement to Congress.
May I ask one more,
Yes.
Senator?
Yes, please.
Well, I'm trying to follow the Senate Majority Leader's logic. What do you have to do to get impeached now? I mean, a felony is not sufficient. What's above a felony?
Well, let's see. Obviously, spreading what they deem misinformation on the internet might be a felony. I suppose at some point.
But it takes, as I understand it, Senator, you're a legal scholar. It takes more than a felony now.
A high crime or misdemeanor.
Yeah,
It takes more than a high crime or
first?
misdemeanor.
What's on second? I don't understand any of this, and I'm very, very worried and would like your thoughts or others' thoughts about the precedent that our Democratic colleagues, in their haste to sweep this under the rug, may have established.
Yep.
Will the gentleman from Louisiana yield for an adjunct question
With
to
pleasure.
his question?
With pleasure.
So the law says that lying to Congress is a felony. Since we're no longer using impeachment as a means to address someone who's lying to Congress, how does Congress prosecute or address someone who deliberately lies to Congress now that the Senate has swept away through this presidential action today the opportunity to use impeachment for that purpose? Thank you.
Yeah, and I'd love to respond to that point briefly, if I could. What we've done is to effectively immunize this against impeachability. Immunize making false statements. And going back to the original question, I don't know, maybe aggravated first-degree murder with heinous, atrocious, and cruel conduct as aggravators, maybe that's still a high crime or misdemeanor. That remains to be seen. But keep in mind, particularly with the fact that they already set aside Article 1, and they've already said that that's out of bounds as well for impeachability. The Supreme Court has said pretty much nobody has standing to address that. What are we left with? And getting back to the question from Senator Lambasts, this is a phenomenally dangerous precedent to have set here, specifically with regard to the false statements. Because what does that do to our oversight hearings, where we rely routinely on testimony provided under oath by cabinet secretaries and other administration officials? What does that do? What incentive structure does that create? What perverse incentives does that create for them to lie?
With the Senator Yield?
Yes.
Are you aware, here's a question, are you aware of the fact that President Clinton